Hello everyone. In this video, I am going to share with you the procedure of alteration of Memorandum of Association. Alteration means any change that is brought by the company in the Memorandum of Association. The Memorandum of Association is a very important document of a company. It is the constitution of the company. So it is not an easy task for the company to alter the clauses of memorandum as per the will of the members. But it can be altered by adopting the procedure given in the Companies Act. The provisions relating to alteration are provided in Section 13 of the Companies Act 2013. Alteration of memorandum may take place in different way. Alteration of name clause, alteration of registered office clause, alteration of object clause, alteration of liability clause, and alteration of capital clause. First, we will discuss the alteration of name clause. A company may change its name in two cases: by its own choice or by the order of the central government. Let us come to the first point, that is, by its own choice. If a company wants to change its name, it may make an application to the registrar for the reservation of a new name. The application shall be made in form number INC1 along with the prescribed fee. On receipt of the application, the Registrar of Companies, in short ROC, may reserve the proposed name for a period of 60 days. On receipt of confirmation from the registrar, the company will call a general meeting and a special resolution will have to be passed for changing the name of the company. Special resolution means a resolution passed in a general meeting by the support of 3/4 majority of the members entitled to vote at the meeting. After passing the special resolution, the approval of the central government is required to be obtained in writing. Then the company shall file with the registrar a copy of special resolution passed by the company and the approval of the central government obtained for the change in the name of the company. On the receipt of the above documents, that is special resolution and approval of the central government, the registrar shall enter the new name of the company in the register in place of the old name. Thereafter, the registrar shall issue a fresh certificate of incorporation with the new name of the company. Now we come to the second case of alteration of name clause by the order of central government. The central government may on its own give direction to the company to change its name if the name of a company is identical or too nearly resembles with the name of an existing company. On such direction, the company shall change its name within 3 months from the issue of such directions by passing an ordinary resolution in the general meeting. Ordinary resolution means a resolution passed in a general meeting by simple majority of the members. The central government may also give direction to the company to change its name on the application of the proprietor of a registered trademark if the name of the company is identical with or too nearly resembles with an existing trademark. On such direction, the company shall change its name within 6 months from the issue of such directions by passing an ordinary resolution in general meeting. The company shall give a notice of change to the registrar within 15 days of the change, along with the order of the central government. Then the registrar will issue a fresh certificate of incorporation correcting the name. Now we move on to the second clause of Memorandum of Association, that is Alteration of Registered Office clause. The place of registered office of a company may be altered or changed in any of the following 4 ways. Changing the place of registered office within the local limits of the same city. Changing the place of registered office from one city to another within same state. Changing the place of registered office within the same state but from the jurisdiction of one registrar to the jurisdiction of another registrar in the same state. Changing the place of registered office from one state to another. We will discuss the first case, that is changing the place of registered office within the local limits of the same city. A company can change its registered office by passing a resolution in the meeting of board of directors. Then the company shall give a notice of this change to the registrar within 15 days of change in form number INC 22. On receipt of the notice, the registrar shall record the same. But this change of registered office from one place to another within the same city does not involve alteration of memorandum. Now we move on to the second case of changing the place of registered office from one city to another city within the same state. A company can change its registered office from one city to another city within the same state by passing a special resolution in general meeting of the company. I have already explained you what is special resolution. So after passing the special resolution, the company shall give the notice of this change of registered office to the registrar within 15 days of change. The company shall file a copy of special resolution with the registrar within 30 days of passing the resolution. Let us now move on to the third stage, that is changing the place of registered office from the jurisdiction of one registrar to the jurisdiction of another registrar in the same state. So a company can shift the place of its registered office within the same state from the jurisdiction of one registrar to another by passing a special resolution and by obtaining confirmation from the regional director. The confirmation of regional director is important. On receipt of the application, the regional director shall communicate the confirmation to the company within 30 days from the receipt of the application. On receipt of the confirmation from the regional director, the company shall file it with the registrar within 60 days from the date of confirmation. And on the receipt of confirmation, the registrar shall register the change and issue a certificate within 30 days from the date of filing the confirmation. The previous registrar shall transfer all the documents and papers to the new registrar. Now we move on to the fourth case, that is changing the place of registered office from one state to another state. A company can change the place of its registered office from one state to another by passing a special resolution in general meeting and by obtaining the approval of the central government, that is, the Ministry of Corporate Affairs. The central government will have to decide the case within 60 days of receipt of application. The central government, before providing the approval to the company, shall satisfy itself that the creditors, debenture holders, and other persons concerned with the company have given their consent in the alteration, or the company has sufficient security to discharge of its all debts and obligations. Company has to inform about the confirmation received from the central government within 30 days to both the registrar of companies. Both the registrar means the previous registrar and the new registrar. The registrar of new state, where the registered office being shifted, shall issue a fresh certificate of incorporation within 30 days. In this video, I have covered the alteration of name and registered office clause. The explanation of alteration of object clause, liability clause, and capital clause will be uploaded in my next video. Till then, goodbye.